Welcome to the Wednesday, November 10th, 2021 Planning Board meeting for the town of Raymond. The Planning Board will come to order. The board does have a quorum, and we'll start with a roll call with you, Kyle.
Kyle Bancroft.
Mike D'Arcangelo.
Greg Foster.
Robert O'Neill.
Ed Kranich.
Mark Child.
And also joining us.
Kevin Woodbury.
Thanks, Kevin. Forgot about you. Also joining us this evening is Mary Koskian, our town attorney. On the public, this is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all the exhibits that are presented. Please notify the chair if you are unable to see or hear. The board works from a published agenda and will be considering tonight's items in the following order. We have a approval of the minutes from our October 13th, 2021 meeting. We have new business, 3 items of new business. The review of the finding of facts for the Port Harbor Holdings. We have a sketch plan review for Raymond Hills and an amended subdivision review for preliminary approval for the applicant R.N. Wiley and Sons. In each instance, the burden is upon the applicant to demonstrate compliance with revisions of the applicable ordinance or state law. All persons speaking shall address the chair. Any conversations must be held in advance until after the board has formally adjourned. After the board votes on the merits of each applicant, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks that those attending the meeting with regard to a specific application not leave until the board has completed its discussion. Appeals from adverse decisions must be filed with the Superior Court or as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual right to file any such appeal, you must be certain that the board records evidence of your appearance this evening. All right, so our first item is the minutes from October 13th. I think there's Sandy gave us a new page 1, which corrected one of the problems. Anybody else have anything that they need to change? Is there a motion?
Move to accept the minutes as written.
Second.
Motion is to accept the Wednesday, October 13th, 2021 minutes as presented. Is there any discussion? All those in favor? Opposed? Passes. Kyle, I got you down as an abstention because you weren't there.
Sounds good.
Okay, second item is new business. This up here. The review of the finding of facts, the historical modification to findings of facts from our Port Harbor Holdings. I'm going to ask Mary Koskian to give us a little overview and let the board know what the court is expecting from us. All right?
Yes. So if you recall, sometime in 2020, I believe, this board approved the application of the marina for an expansion that has been appealed to the Superior Court, and Justice McKeon remanded on one very, very narrow issue. I'll read exactly from his decision. The court remands the matter back to the Planning Board for further findings, but the very specific section is the findings related to the shoreland zoning criteria that the project will conserve visual as well as actual points of access to inland waters. So that is the criteria. In your findings of fact, and I have it pulled up here in front of me, under that criteria you said no visual buffers will be impacted by the proposed project. And then the applicant notes that a utility trench will be excavated to install a new fire suppression system, and the excavated area will be restored and stabilized. That probably goes to shore cover. When this topic came up at the meeting, and that's noted by the court, I provided information that typically, because you don't have any guidance on this criteria, and it's pretty subjective and vague, and we look to how that's been applied in other circumstances. And in my experience, that type of criteria only applies to public, because it's talking about a visual access. And so that generally, and in my experience, always applies to, you're looking at the public points of access to the inland waters from a visual perspective. When Justice McKeon looked at this, he concluded that he couldn't say as a matter of law that the ordinance language applied only to public views. And that was because it really wasn't, there wasn't a lot of briefing on that issue, because it's just kind of a given and a standard that we apply. I mean, DEP has a lot of visual impact standards and a lot of the things that they review, and they never look at private views. It's always about what type, when you're conserving and protecting, you're conserving and protecting a public view. And I say that only because my advice wouldn't be any different today. But what the court goes on to say is that the planning board does have discretion to put more weight on public views than private views. The board can weigh the size and type of location that a view is disrupted and size and type of disruption. It's a highly factual inquiry. The finding of fact that said there's no visual buffers impacted, just he wasn't able to tell whether your findings were supported by the evidence in the record because they weren't further elaborated. I imagine that standard was drafted after this conversation of this board. Generally, when you're talking about visual buffers, you're talking about something that's been conserved and preserved for a public view. You've created some buffers and you're allowing a public view. Here, the complaint is that the view from the Indian Point Beach is going to be impacted. Again, it's not visual impact, it's whether visual points of access are preserved. And so I think this board needs to elaborate further on its findings that has been met, and you can have a conversation about public versus private. This would be a change if Justice McKeon saying that it applies to private property would be a big change in the law, but I do think that you can talk about it and whether you think that, if there is a point of visual access there and whether it's been preserved and whether, putting a marina there or expanding the marina there does anything. I will say that the court, and I also wanted to say that Justice McKeon is relatively new to the bench and we've seen a lot of remands. So I don't want you to all think that you've done something like, so wrong, and I can't believe it's, because it's, you can't help but feel that, but I've done many of these remands since he's been on the bench, and he's done a lot of them, and I'm sure Keith and Leah have also done that. So don't feel, he just likes a lot more detail than your average judge. I will say this is not an opportunity for reconsideration. What you're doing is you have your finding that it meets that standard, and now you're going to be providing additional findings to support that conclusion. And so I know the parties have, the two attorneys have submitted some arguments, and I believe this board is going to just let them summarize that, but really tonight is about the board just going back and looking at the record and adding some more findings. I reviewed the record, and there are a couple of, the place where it is most discussed is there is a letter, and let me get to it. There was a letter from the applicant to the code enforcement officer in response to this issue. And of course, I think it was March 2nd of 2020 is the date of that letter. And there's a lot of information in there about the points of access, the visual access. And I believe there were, the presentation before you had, images of what it could potentially look like. And so that's really the information that you're looking at that's already in the record that you would be making your determination. So just additional findings as to why this meets that standard. Again, it's whether it will conserve visual as well as actual points of access to inland waters. So visual points of access.
Thanks, Barry.
Good.
Go ahead, Kevin.
Can I make a comment?
Yeah.
Now? So, remembering our site walk over there and reading all this stuff, I mean, I can understand their point of view that their pristine visual access is being impeded. But when we looked over there, we still could see with the docks that are there, we could see those. So their access, their pristine access is already impeded. They're just going to impede it a little bit more. Everybody remembers that we could see from the beach the docks that are there already?
Yes, yeah.
So their visual access is not perfect, but you can still see by it to the other side of the lake. And I agree that their access is going to be impeded a little bit more, but it's not blocked.
Kevin, I'm going to ask you to hold for that, and we discuss it as the board. I'm going to let the attorneys that are present have a couple of minutes to summarize their letters, and then we'll get into the discussion. I thought you had a question. I'm sorry. All right, so I do understand that there are two attorneys here this evening. I think we have received both of your letters. I think the board has all had a chance to read them. Am I correct in that assumption? Yes. Okay, so we've read your letters. If you would like a few minutes to summarize those letters or just talk about something that specifically addresses the visual points of access, that would be fine. There's no reason to go through the whole letter again, since we've already had it. But if you would like a couple of minutes to do that, this would be the time to do that. I would just ask that you proceed to the podium, state your name and your affiliation with the project, and then take a few minutes to address the board. Is there either attorney who would like to do that?
I'm happy to go last or first, whichever.
Oh, the applicant.
Okay, fair enough.
Draw straws.
Good evening, Mr. Chairman, members of the board, members of the public. I'm Leah Rachin, and I'm here on behalf of the applicant who was the party in interest in the case before you. I just wanted to talk quickly about how, as you know, your decision was upheld on every point except for this one, and it was not overturned, simply just requesting that you make more specific findings as to why you decided as you did. And it's our submission. I was going to go into the legal aspects, but Mary has already very much summarized them as exactly as I would, and I think that we respectfully disagree with the court. We think it is clear, and we agree with Mary's analysis as she set forth, as she just said, explained to you why. But particularly here, I think the facts with respect to the standard of conserving visual points of access. Also important to understand the standard of review here is that I think what the court telegraphed to you is, what the law is that it's a highly deferential standard on factual findings. And so, if you make factual findings that are supported in the record, and I'm going to outline what that record is, and I think it amply supports a factual finding that visual points of access are conserved, that your decision must be, not just should be, but must be upheld even in light of contrary evidence. And so I do want to talk about what that evidence is. First and foremost, context is important, as I think one of your members talked about, is that this is not, as we know, a pristine stretch of shoreline and water. It's Sebago Lake, one of the most highly trafficked and enjoyed lakes in Maine. You have an existing marina already, Port Harbor has an existing marina, 77 slips. You could have, the folks at IPOA could already see those docks. There's another private marina within 0.18 miles. This is all in the record. This is the record evidence. There's also a large marina owned by IPOA itself, owned and operated by them. And there's another public boat launch. So again, not pristine, highly trafficked. Extensive testimony that you had over the course of at least a couple of hearings. Photo documentation from the applicant's representative, Mr. McSorley. And I think what's critically important here is forget about our evidence. Forget about the evidence that we submitted for a moment. I think what's most compelling is if we look at the exhibit that IPOA and Mr. McKay himself submitted to you as part. And I'm just showing you that that's sort of the rendering of before and the projected after. And, I'm not sure if this is just to scale, and I'm not conceding that it is, but looking at this and accepting it to be true, it still unequivocally meets the standard. You look across, you see the water. You see across the water. You see the tree line. It's my understanding that the view of Douglas Mountain won't be obstructed. And so I think what's critical is to look at that language. It does not say there can't be any impact. It doesn't say if there's any impact at all, then you can't approve it. It simply says that it must conserve points of access. Looking at their own photograph, it absolutely does. Just from a practical perspective, I think we need to recognize docks are flat. Boats of this size tend to be 4 to 8 feet above the water line. Again, that is not an unreasonable detriment to a view. And again, I think as Attorney Costigan said, we're not talking about views here. We're talking about points of access. The other thing that I want to point to in the record is DEP's visual impact study. Again, ordinarily that wouldn't be relevant here, but it is part of the record because so many of the NERPA standards are almost verbatim to the ones that you were considering in your review of this application. That entire application was submitted. There was a visual impact study. DEP folks went out, did their own personal observations. They found, and I'm just going to read what they said, that the location and scale of the proposed activity is compatible with the visual quality and landscape of characteristics found within the viewshed. So that's not determinative. You don't have to adopt what DEP says or thinks, but if you find that that's consistent with your own perspective, that's absolutely another piece of record evidence that you can rely upon. Excuse me. I think the most important thing here is the fact, not what I'm saying, not what they're saying, what you saw. I do recall during this process that you were legitimately concerned about views and other impacts on the residents of the IPOA. And so you went out, you conducted your own site visit. My understanding is that during that time, you saw with your own eyes the possible impact. It's also my understanding that it was staked out, the parameters of where this was going to be. You saw with your own eyes what the possible impact could be. And that personal observation led you to conclude, rightly so, that this standard was met. And so just distilling it down to its essence, we think you got it right, both factually and legally. And so we're asking, A, that you uphold your decision, that you issue findings consistent with the evidence. And I think you probably saw that in our submissions, we offered some draft findings that hopefully will help you along the way. But I thank you for your time and happy to answer any questions if there are any.
Thank you. Thank you for keeping it short.
Thank you, members of the board. My name is Keith Richard, and I represent Barry McKay and Wayne Quagliaroli of Indian Point Owners Association. There are two owners, but they're two of many folks at Indian Point that are concerned about the impacts of this project. Now, I don't agree with some of the characterizations of what the Superior Court has instructed this board to do, and I would encourage you to read directly what the court ordered. I included that as an exhibit to my letter. The reason that this board concluded that there was no impact and that the visual standard was met was because you didn't consider the view from Indian Point. And the reason that you didn't consider the view from Indian Point was because you had legal advice that the ordinance protects public views only, that you can't consider a view from private land. And that simply is not accurate, and I'll explain that a little further. The credible evidence that's in the record before you that was submitted and basic common sense would lead you to conclude that Section 16D5 is not met. Now, what the Superior Court concluded was that the finding that no visual buffers will be impacted by the proposed project, it wasn't clear how the board applied the facts and the evidence to the ordinance. And the court specifically rejected the argument that public views only are protected. That's not what the court concluded. The court stated, quote, "There is no distinction between public and private views in the language of the ordinance." That's a correct statement of law. The court further found, quote, "Here there is evidence that the marina expansion substantially impacts the view from IPOA's beach." That is a correct statement of fact. The uniform public comment that you heard in February and March of 2020 was that this project ruins the view of Sebago Lake for Indian Point. Exhibit A and B speak to that. We've blown up the visual that depicts a before and after. I would suggest that that doesn't actually reflect how bad it is, because pontoon boats are much taller than the boats that are depicted in that illustration, but that's neither here nor there. The obstruction is clear and it's unmistakable. You don't need legal opinions, you don't need engineering opinions, you don't need bureaucratic analysis or DEP analysis to see what we can all see with our own two eyes. And I think that everything you need to know about whether this conserves visual access is in that illustration and is a basic application of common sense. You heard from David Bernard, Allison Allen, Alan Doherty, William Groves, Rachel Sarna in February of 2020, and they all spoke about how this is a direct obstruction to a view that people have enjoyed of Sebago Lake for decades. It has rendered their enjoyment of the Indian Point Beach unusable. And the proximity of this project, it really is never going to be the same for these folks. I want to be clear that the suggestion that where this expansion is located is in some area where there's plenty of slips, lots of boats, lots of docks, that's just not an accurate statement. The Port Harbor Marina slips that were there before were located around the corner in a channel. Panther Run Marina is way down the other end in another channel, and Indian Point slips are not visible. So it's the idea that this is in an area where there are already a bunch of boats really is an overly narrow, and it's a mischaracterization of the record. I think that more compelling than anything in the record are the statements that we heard from the board members themselves. And I have submitted to my letter a transcript of the March meeting. And at that meeting, on page 69, Mr. Sanford stated, "I understand, Rob, your statements about holding a ruler up or holding a popsicle up and saying that's how much that's going to impinge your view of the water. With all due respect, I think the photograph on page 3, which is that depiction, photograph on page 3 of this presentation shows the before and after view of what it's going to look like from the beach. It's a much more reality-based view of what's going to happen to the view from the beach." Now, similarly, Mr. Woodbury, on page 76,
Mr. Richards, you're coming close to your 5 minutes, so if you want to summarize, now would be the time to do it.
I'm sorry, I didn't hear that there was a 5-minute limit.
You
I
have your
didn't
5 minutes.
understand that that was imposed on.
So I would suggest summarizing fairly quickly.
Well, it's respectfully, sir. That's not what was stated at the beginning of my presentation.
Yes, it was stated. I stated that you had to summarize your, in a relatively short period of time. I gave 5 minutes to the other attorney. I'm giving 5 minutes to you. You can have another minute to summarize, but that's the end.
The Port
Okay,
Harvard.
that's fine, then you can sit down. Thank you.
No, I'm going to finish my
Oh, okay.
presentation, Mr. Chair. Thank
No,
you.
you're not. You're going to take one more minute.
I am going to finish my presentation, Mr. Chair. I'm going to finish my presentation. Thank you.
No, the board is moving on. You
I
continue
am
to
at the
talk.
podium, sir. I'm going to finish my presentation.
Could you turn that speaker, the microphone off that's at the podium, please?
There is a distinction.
All right, would you
There
kindly
is-
sit down? I mean,
Sir,
your time is up, sir.
You gave me another minute. I'm going to use it.
All right, you may have the minute.
There is a distinction. There is no distinction between public and private views that's made in your ordinance. Justice McKeon is not changing the law. Your ordinance says what it says. If this town of Raymond wanted to make it so public views only were protected, you amend your ordinance for it to provide for that. Your ordinance doesn't make that distinction. It's a material difference. And I think that Justice McKeon was correct, and this board should apply the law. To do otherwise is just willful blindness. Thank you.
You're welcome. Okay, Kevin, now for discussion.
Okay, so back to where I was, reading what the judge has said and everything, and reading what I see as being the way the statutes are written, which is different from my personal opinion, because I did, like he was just about to say, your eye does go right to those things, and it ruins the view for some people. But that's not what the statute and the justice and what I'm understanding the law is. You'd have to have something a lot higher that blocks the whole view. And if you look at the picture again, you're blocking just a little portion of the view. Even though it does ruin it for a lot of people, you're just blocking a little tiny portion of the view. So I don't know I think we made the right decision based on the law. That's my understanding.
Mike?
Well, I'm comfortable applying the visual points of access to a private view, partly because the law court said that perhaps we should. Our ordinance says will conserve visual points of access. It doesn't say all, and I think in this case, like many cases, it's a bit of a reasonableness test. Now, I get the fact that anybody at Indian Point wouldn't want their view at all impacted. I understand that. But on the other side of the coin, businesses have to be able to predict what they're going to be allowed to do, and I think that's a reasonableness test. In this case, I can see from that picture, looking to the left, there's unobstructed view. In other words, the dock coming out only goes so far. You still can see water past that. You can see the tree line. Yeah, there's some view impact, but to me, not enough to make this project not in compliance with our ordinance.
Mr. Foster, anything?
Well, since I deal with forest land, one of the issues that we deal with is property rights, and a property, you have a certain bundle of rights, but I believe, and Mary can change my mind if she disagrees with me, that property, a taking can take almost all of your property rights as long as they don't take the last blueberry that you can sell. And if you use that sort of analogy in this case, they certainly haven't taken all of your view. That's all I have to say.
Ed?
Well, I think the applicant met all the requirements that we evaluated. And it is his property, he has a right to use it. If I build a barn in my backyard, my neighbor doesn't like the way it looks, it's impacted his visual rights. So I see that as an analogy for this case. I agree with what we originally decided as far as the impact, visual impact. Even if, you know, you do apply it to a private site rather than a public impact. So I think even taking the most, you know, strict sense of the wording, that the project did meet what was required as far as preserving visual impact.
Okay, I will just add to what some things which I've already talked about is I don't think that a marina is an unexpected business in a commercial area on a major lake. So yeah, I'm sure that boat traffic has impacted the visual sight distance, but boat traffic is something that is also expected on a major main lake, even minor main lakes. So I think that the expectation that the property bordering properties is never going to change, nor will it ever be allowed to change, is not realistic. It's not a fair expectation to be placed upon abutters. So I think that we're in the commercial zone. Marinas are an authorized use in the commercial zone. Yes, I would agree with Attorney Richards that there has been a minimal impact to the sight distance when looking to the right from the beach. But we've all been out on that beach, we've all viewed it, and we've all looked at it before it was constructed. But it was the winter time, so we were able actually to walk out onto the water and see where those spots would be, where the marina would be constructed. And looking back, it was not a problem in seeing where the beach area is. So, I mean, I understand the concern, but I do feel that the board has properly tested the ordinance in this regard and found it to not be a reason why the project should not have been approved. Is there anything else that you can't say anything? You can't say anything. So, Mary, do you have anything that you want to add or question?
Well, let me just summarize what I've heard because I'll draft something up based on this. So what I've heard is that for, you know, taking the court's lead, you are analyzing the view from Indian Point Beach as a visual point of access and asking the question as to whether this proposed marina expansion will conserve that visual point of access to the lake. And because that expansion does not entirely block the view and there still is a visual point of access from that beach to the lake, you feel that that standard has been met. And that's based on both your site visit and visual and other exhibits submitted to the board.
Correct.
Yes.
Is
Okay.
that
I think that's a good summation.
Kevin?
Yes, that's perfect.
Okay.
Excellent. So I will write that up and you can, I guess, vote on that at your next meeting or just accept it. I don't even know if you need it. It's not like a finding of fact. So I think that's enough. I'll just, we have that recorded and I'll do that verbatim.
Do we answer to the court, or do we have to just add to finding of fact?
We'll just add it to the finding of fact and give it to the parties. The court has not retained jurisdiction, so it's up to the parties the next step.
Do we have to vote to accept the
I think,
findings?
I think you can move to accept the addition to the findings that as I just laid out.
Yeah, I make a motion to approve the findings of fact revision or addition as
I'll
Mary
second.
Attorney Costigan just expressed it.
Okay. Mike has seconded. Before I call the vote, just out of fairness, Attorney Richards, if you would have a question for the board before we can vote, I would accept any question that you might have at this time.
No, Mr. Chair.
Okay.
Thank you.
You're welcome. All right, all those in favor?
But because Kevin's remote, you're going to do a roll call.
Oh, do we have to do all roll call? We usually just
Yeah.
have him say,
I would do an entire roll call.
Okay.
For the people who are also remote.
Kevin, for or against?
4.
Mike,
4.
4.
for,
4.
abstain.
Okay.
Okay,
Yep.
so we have, what's it, 5? 1, 2, 5, and 2 abstentions.
Okay.
All right. Dustin, you out there somewhere?
Good seeing you.
Dustin, you know our time limit? We've already, yep. You've already talked, someone told you about that, but I think it's, some of it's been preceded by some other conversation, right? Is that what I gathered on the projects?
Which one?
On the Raymond Hills? Thank you.
Yeah, so for the Raymond Hills application, we did make a written request into the town today that we're gonna table that for tonight's meeting, and we'll continue that discussion at a subsequent meeting when we submit more substantial information for the board to review. So we didn't wanna waste your time tonight with another sketch plan. We're gonna clean that application up and get more information in there, and we'll review it at a later date.
Okay, perfect. I think that this project has already been tabled. So I think we will just leave it there.
All right, yeah.
Okay. So the R.N. Wiley, the Boulder Road project. Mr. Seymour?
That's me. This application is back to you this evening for consideration for final approval. It was,
Oh, I'm sorry, before you start, it is on the table, so we do have to get it off the table.
Correct.
I'm sorry, my fault. So I need a motion to remove the Boulder Road project, Patricia Ave, from the table for consideration.
So moved.
And seconded.
Second.
Any discussion? All those in favor?
You're gonna use it after that.
And Kevin votes yes, the Zoom. Okay, I'm sorry, go ahead, Jim.
no, it's okay. At the last meeting, you did vote for preliminary approval, subject to cleaning up some of the items that were left over. One of the larger ones had to deal with the DEP and where they were with the stormwater. There is some more information with that, but I'd like to just go through some of the other items first, following my memo. With regards to the typical criteria that we have, I'll just go quickly through those, the ones that we might want to think about as a condition, or you might want further discussion on. The first one had to do with flooding, undue air pollution or anything like that. They did submit a FEMA map that does show that it is not in a flood zone, but due to the fact that we know that there's a substantial wetland nearby, I did make the recommendation that at least the finished basements be set 1 foot above the final grade of the wetland so that we don't have flooded basements there. Number 2, soils. They did provide information that does comply, the proposed septic systems do comply and are adequate distance from any stormwater infiltration areas. 3, land and slope. That is all adequate, and they have provided a nitrate study to further back that. The next one I have is B, has sufficient water available for reasonable foreseeable needs of the subdivision. The fire department did have a separate memo, and Wayne is here to discuss anything from that, but I think most of that has been met, but I typically like to keep those conditions in there from the fire department, just so we can make sure they're all met. Moving on, I had nothing for water supply. Each lot will be sprinkled and have wells. They have included a well exclusion at this point. D, I had nothing with erosion control. E, highway public. I'll just give you a quick overview. We did meet with Nate on site to look at the entrance off Patricia Ave. Patricia Ave is kind of has a super elevated slope at that area because it's on a bend. We both felt that given the slope of the super elevation, that the 4% grade coming off would be the best solution. And we did provide Dustin with some ideas as far as how we'd like to have the drainage corrected at that intersection, and he has implemented that and put it on the plan, so we're satisfied with that. Nothing with soil and sewage waste, that's all in the homeowner's documents. Nothing in G, nothing in H. I, undue adverse effect on scenic and natural beauty. This is where we start getting into some of the DEP discussions, and maybe what I'll do is I'll just let the applicant follow up with that one, and we can have a separate conversation, because that one's a little complicated with some of the other things going on in the nearby town of Wyndham. That gets on to K. We still have not received any financial information of capacity to date on this, so that may be a condition you want to consider, or you may want to see that ahead of time. Nothing on L, nothing on M. As far as N, we've already discussed that as far as the flooding near the by wetlands. Nothing in O, nothing in P, nothing in Q, because Q already deals with the DEP, which is part of the DEP review. And I had nothing else other than at the final plan signing, we will need a surveyor's stamp on the final plan before the board can sign. I think the DEP is probably the biggest issue that the board may have some concerns for, and I think it's just best to let the applicant discuss where they are with that.
Yep.
All right, I can take it from there if you'd like. Yeah.
You're up, Dustin.
Sure. So there's 2 points that I just wanted to bring your attention to. One is something that Mike has brought up consistently at some of the other meetings regarding the minimum lot size. We had a kind of a misinterpretation as far as there's some discrepancies between a 40,000 square foot minimum lot size and then a half acre when it comes to doing the cluster subdivision. So what we've done on the plan that we have in front of you here tonight is we have increased the lot sizes on lots 4 and 5 to be 0.55 acres. So we've added some additional square footage to those lots. And what we've also done as well is we've expanded the open space to be 3.82 acres. And what that is if you were to add up the square footage of each of the 9 lots, and then you add it to the 3.82 acres, that gives you the required 40,000 square feet times 9 lots. So I think that's what the intent of the ordinance was, and so we did make that change on the plan here, and we had just emailed that over to the town for the record. So just wanted to let you know and apologize that you had to bring it up several times throughout this process, and we finally got to the bottom of the ordinance, and I think we got it straightened out. As far as the financial capacity letter, we did get that from Evergreen Credit Union. They reviewed the project financials and had provided a letter. So again, that just got emailed over to the town today, so it's in there for the file. Regarding the DEP permit, the discussions that were had that kind of delayed this a few weeks were just because the adjacent project that was on the Wyndham land for the solar project, those 2 projects were kind of happening at the same time. So the DEP did take a pause and look at those 2 projects just so they could make a determination that they weren't linked together as one big project. There was some initial discussion to potentially use the Boulder Bend Road for access into the solar site. That was investigated briefly, but the solar project has decided to continue to access the project from Pipeline Road. So they're not sharing access roads, and the criteria that the DEP used to determine whether they were one project or 2 was whether they were going to share an access point, have common stormwater management facilities, or if power from the solar project was actually going to be conveyed to the subdivision to be able to use power. So none of those criteria were met, so they did make the decision that these are indeed separate projects, and they're taking their own separate paths. So once that decision was made, the engineer completed his technical review and signed off on the stormwater components. The project manager that we've been working with, Jen McGill, had a couple of questions just about documents on wetland impacts, which we satisfied. So she did provide us an email earlier this week just indicating that she was satisfied with the information we had given her, and that the order is being written up at this point, and we're not expecting any more further discussion. So we provided that correspondence email chain to the town just so that there's documentation there that there's not anticipated any more further review on the project, and that we're just awaiting for that final signature on the permit order. So what we'd be asking the board for tonight is a waiver of the road standard to allow that 4% slope for the first segment of the roadway. And with that, I believe a condition that the final permit order would be provided to the town prior to the planning board releasing any signed plans for the subdivision would be appropriate. And we've got a number of fire department conditions and things that Wayne has put together in his memo, which we're agreeable to adding all as conditions on the plan for fire lane signage, sprinklers in the buildings. We're also agreeable to putting a gate at the end of the roadway with a Knox box that would potentially provide emergency access to the adjacent parcel if it's needed, but it would be closed to regular through traffic. So I think with that, I'd like to turn it back over to the board, and we're happy to answer any questions.
Thank you. Justin?
Mr. Chair, if I could, just so there's some clarification. The solar farm will be accessing the right-of-way Boulder Bend, with sort of the south side of Boulder Bend, because Boulder Bend, as you know, is a right-of-way that continues from Patricia Ave and goes to Pipeline Road.
Mm-hmm.
So they'll be using a portion of the right-of-way for their own development, separate from the subdivision, but they're both on the Boulder Bend right-of-way. But they're blocked from using each other's, basically, so they're not utilizing the same portion of the right-of-way.
Oh, I see. Okay.
Is there a gate?
Yeah, there's a gate, and there's an undeveloped section between the two projects.
Between the two projects. Okay.
Jim, I noticed there was you noted there's a little concern about the curve and the site distance.
Yeah, we did look at that too at the same time with Nate. We did feel that, given the speed limit through there, that there was adequate site distance at that point, and there is no obstructions. It is at a good location where there is no visual barriers back behind the, just even beyond the right-of-way line. There's cleared areas, so it does have good access on both directions.
Would it be reasonable to ask for a evaluation on whether signs should be put on Patricia, like just showing symbols for a intersection?
Approach, entrance or
Yeah.
I guess I'd put that back on the applicant to maybe have the traffic engineer look at that. I don't, maybe that's even a Nate call at this point, because it'll be going in the town right away, but if such a sign is required, then maybe we could put it on the applicant to pay for the sign. That'd be the only thing that we would.
I've noticed on my way here on Mill Street, as you're coming up Mill Street to 85 here, it says dangerous intersection ahead. But when you're on 85, there's not even a sign giving a symbol of intersection.
Right,
So you kind of got to look for it if you know it's there. So, it would be a situation like that where I think it could be improved with just a couple signs.
Yeah, we could put a
3 foot.
condition that says that the condition could be reviewed with the public works director, and if signage is required, it'd be on the applicant to provide that.
Yep. Yeah,
I
we're
don't
agreeable.
think there's anything from a traffic standpoint that's required for the sign, but if it helps improve safety and the public works feels it can improve safety, then there'd be no harm to put it in.
Yeah, I think what you'll find in most circumstances where those signs are installed, it's where driveways don't really have the site distance that's required, but the driveways are there, there's nothing you can do about it, so the signs are up as a warning. In this case, we do have adequate site distance in the location where the driveway's going. And I think once the trees are all cut where that road's gonna be put in, it'll even open up that area that much more. So I think right now, as you're making that corner, it's a little hard to visualize how the road's gonna come in. But once that's all cut, it's gonna be wide open, and I think it'll be a very noticeable intersection.
Another thing that we could do, and I don't know, are there any poles near that intersection right now? The other thing we could do is we could put a light, because a lot of the roads that we do have issues like that, we have a street light at that intersection to help light it up, so it's just not a dark corner. That may be something else to consider, the board may want to consider, is to put a street light, and that's not unreasonable, we have done that on other private roads before.
Yep, that's fine with us.
Okay. Yeah, I don't want to do the engineering, but
No, I
whatever seems
understand.
appropriate, you know, based on the sound.
And again, I would leave that jurisdiction, and that probably would be up to the jurisdiction of the Public Works Director either way.
Yeah.
But as far as the light condition, that is something that you would have the authority to require on the plans, and then you could have, we could put a condition on there to work with the Public Works Director for appropriate signage of the entrance.
Jim, or actually, Dustin, either one of you could answer. It's not really project specific, but as we put more houses back in that area, we kind of are going to increase that traffic that tries to get out onto 302. Does DOT do a study on the 302 impact to the additional now cars that are going to be trying to make a left-hand turn in the summer, in the middle of the day?
What would happen here is, we look at it from the standpoint of what does the development itself generate for traffic, and it itself does not warrant a traffic movement permit.
Right, and I'm not trying to put it on.
I understand what you're saying. I think periodically DOT does look at points of intersection and makes, I don't want to say annual, but they look at periodic assessments of danger locations based on accidents and things like that.
Right.
As they just went through that area, they may have already assessed what each intersection may be able to handle and flow. I don't think you'll find that the number of trips generated from the subdivision would warrant any other things like that. And as far as I know, I don't believe that there's anything we would have to go back and ask for it, but I'll let Dustin further address that if there's anything he's aware of.
No, I mean, for a project like this, there really isn't, a traffic mitigation that would happen, but I think.
No, I'm not asking.
Yeah, I think what DOT does is they collect and analyze accident data on a regular basis, and then once an intersection gets to what they can call a critical rate factor, there's going to be a certain number of accidents, and it has to be a critical rate factor associated with that intersection. At that point, it becomes a high crash location. And then that gets built into their assessments going forward. If you are contributing additional traffic to intersections, they look at those much more closely once they've been identified as a high crash location.
And I think if the town itself feels like that is an intersection of interest, then they can solicit DOT to look at that as far as number of trips going through there and if there are any mitigation things that can be done in the future.
Seems kind of backwards. You have to prove it's dangerous by having enough accidents to
Yeah.
determine.
Yeah, but if it.
We'll fix it when someone gets really hurt.
Yeah.
If this project had warranted enough trips to trip that generation, then DOT could make them go back to that intersection. But
Yeah,
it's gonna be a trigger mechanism to get to that, unfortunately, to your point.
Okay, thank you.
But in looking at future projects up through there, we obviously know there's quite a bit of land up in there.
Right.
We looked at another project in there. That's something definitely as a town we can kind of keep an eye on as far as, at what point, because there's several of those roads that come down in the morning especially, or in the afternoon.
Yep.
It is difficult to make a left turn out. So, the only light we have really is up at 85.
Yep.
And everybody else, it's kind of like floor it and get out, right? So it's the ongoing battle that we have through the strip, basically.
Questions from the board? So, Justin, did you give us a written waiver request? Did I miss it?
I
I don't.
don't
I might
recall.
have missed it. I don't recall seeing it, but.
Don't know, didn't see it in the last one. I don't know if you have online the previous applications. I know we brought it up at the last meeting.
Yep, we talked about it.
We talked about it, but I don't.
Is there an
know
actual
if there was an
form, or is
actual-
it?
No,
something- No.
there's no actual form. It's just a written
Okay.
request and with reasons why you need the waiver.
Okay. Yeah, I can certainly follow up with that. You know, basically in the testimony, you know, we talked about it last time, and just to summarize, the feeling was that by flattening out the road near the entrance, it would actually require steeper grades to get up to where the high point of the road is. So we felt that having a more gradual transition up into those steeper slopes would create a better transition for folks coming down the hill, entering the roadway intersection. So the board felt it would be appropriate to have the Public Works Director review in the field these conditions and provide a recommendation of support for these specific road grades that we were proposing. And we did meet with the Public Works Director and the planner, and we were all in agreement that what was proposed was the best solution for this intersection.
Yeah, I don't think, I can ask the board, I don't think the board has any problems with the 4%, do we?
No.
No, yeah, I don't think, it's just, it's really a procedural thing.
Yep.
In order to grant the waiver, we have to have it in writing, because we don't do it without it being in writing. And to be perfectly honest with you, I've only done it once with it not being in writing, and it got kicked back
Okay.
because it wasn't in writing before we granted it, as simple as it was. So I do have to have it in writing before we can actually grant it.
So,
Can I handwrite it here, or I don't know if it's something to come back for another meeting?
I'm just wondering, with we haven't, I have not, and I don't know if the board has, reviewed the financial capacity.
No,
We just got that this afternoon. We got the correspondence from the DEP. I'm just wondering if we go through the criteria that we do have,
mm-hmm,
you individually vote or decide whether you're okay with those criteria, and the ones that we have a couple loose items on, we hold off on, hopefully between now and the next meeting, we actually get the physical DEP approval.
right, I think we can count on that DEP approval, but yes, you're
Yeah,
right.
but I'd like to, I think we'd like to start the precedent of having that.
Well, we do, that's no precedent, we require.
Yeah.
So we get that physically in
Right.
writing, but what we can do is to help streamline the process, if we're comfortable with all that, and it's just really procedural things, I can prepare a draft findings of fact and have that ready for the meeting with the understanding that we'll have all these stuff ready for the next meeting, so that, because typically we have a 30-day delay between the findings and the.
Right,
So we could kind of consolidate that to one meeting if tonight you can roll through the majority of the other items.
okay.
But I'll leave that for the board to decide if they're.
No, that's
okay.
fine, I know in your write-up, you said they probably would be ready for approval this evening, and then, I know there's some outstanding things, some things that are in the works.
And I know the
there.
DEP is one that we're very sensitive on now. We're
Right.
gonna really be strict on as far as making sure we have those in hand.
Right,
I know that they're very far along and they're close, but close is only good in horseshoes and hand grenades. right?
yeah, well, I think the last thing I read was it was being prepared, right, isn't that?
Right, yeah.
Okay. All right, so there's that, so we'll go through the items that sound okay to the board, and then we'll just,
And just, and just, I have, going through this, I think I have 4 conditions, based on what I went through earlier, and those did include the DEP. I don't know if, Wayne, you have anything you want to discuss with the board on this one or not? Well, you got this one, right?
Note the applicant has addressed the issues and concerns that we had. We would just ask that our memo of the February 26th be added to your findings of fact.
okay.
I guess I just asked, does the board need to vote to grant preliminary approval before it grants final approval, or no?
No.
Okay, I just didn't.
Well, we did vote
don't-
last time. Did we do last time we voted preliminary last time?
No, this
No.
one,
I know
no, we're not.
on Raymond Hills, we voted preliminary approval on.
Right,
This
and then
one,
we
this
took it
one we
back.
have
This one
not
we've never
yet.
voted
Okay.
preliminary approval on.
So then I would recommend that you consider this for preliminary this evening, but you hold off on final until you have those other items.
Yeah, I think that's a perfect way to go. And that's more procedural for the next time.
Right.
Yep. And Dustin, that, the written waiver can be like 2 sentences.
Yep.
It's not a.
Yeah, I was just going through my emails to see if I had included it, but I didn't, so
Okay.
I'll follow up.
But that can be wrapped up at the final too.
Yep. All right, so, does the board have any specific questions on each one? I'm not sure.
Well, yeah, the first one, setting the basement grades, finished grades 1 foot above the wetlands. Is that on your plan already, or is that something that you had?
What we were planning to do is if the board were to vote on and attach conditions of approval, we would then attach those to the plan before you signed it.
So we can grab that now, and
Yeah.
it won't become a condition. It will be eliminated in the condition if they put it on the final plan, basically.
Okay.
Okay.
As with the financial capacity, as would be, well, the fire department memo we put on still as a condition, but, yeah, the DEP note would be approved, and so would the financial capacity, so we really only have one condition at that point, which would be Wayne's memo. Everything else would be addressed at the final plan. So I think you could make a motion for preliminary approval, subject to waiver request being submitted in writing. The note added 1 foot above wetland elevation, and written DEP approval. And Wayne's memo, but Wayne's memo is probably going to carry on as this is the standard condition. Yeah.
Dustin, we talked about some sort of markings for the wetland / common land.
Yep, I think we've added those. Yeah.
You've added those, okay.
Yeah, oh yeah, and I did want to mention that too. Yes, they have revised the plan to include the additional areas per your uncovering, and obviously Alex and I have agreed that that's a little bit of a snafu in our ordinance because the village allows for 20,000, but the open space subdivision says half acre. We think it's some terminology that has to be, again, it can be cleaned up with some ordinance changes, but the fact is it says half acre, and a half acre is 0.5 acres, not 20,000 square feet. So they have revised that. The open space does meet the criteria under the open space. We'll follow up with the final review once we see everything, but they're on the right track.
And we also,
There was one other, which was the note about adding a street light, and they can add that to the final plan now, and as well as anything requiring a street sign by the Public Works Director.
but before we go down the streetlight, are there houses near where that streetlight's going to be placed?
There is, there are houses there, but I
Yeah,
think that
there's-
pulls back a little bit, but.
There's basically 3 on that corner. But, I mean, these lights are, if you mount them on the utility pole, they're up pretty high. It's a lot better than like a 12-foot pole-mounted one, which everyone will see.
This would be on a CMP pole.
So this would be a Cobra head on top of a CMP pole, so it would light the intersection up without, shining at somebody.
Okay.
So,
Yeah, that'd be a pole down. These are now LED lights that go straight down. So
Okay.
they would light the intersection, and I think everybody would feel a little more comfortable in that area too, because it is a pretty sharp corner, and there's quite a few people that come down and around, and quite a few that go up. And matter of fact, the day we were there, people were going at excessive speed, so.
It'll be a good idea whether the subdivision was there or not to
Right.
have a light there, so.
Okay.
yeah.
What else do we have? Greg, anything? Mike, anything? Hal?
And on the other items that Jim listed,
Yeah, financial
Means
capacity,
for
we'll review that, we got that
transformer
this afternoon.
yeah,
Then, we'll double check all the spacing, but, based on the calculations, it appears correct. we'll double check those as part of the final review, and financial capacity, I discussed that, and DEP is really the big one that we're holding our breath on.
Yeah.
We do have draft HOA docs as well, and we included those in the email today, so those,
Yeah,
just so you had those.
and the stuff I gave you tonight.
So,
Okay, I don't see any reason to go through as far as preliminary approval goes, or even final, each one of these items, blow by blow. Does a board member prefer that I do that? I'm sorry, Mark.
No.
I just want to explain to Mark. Before you say names. Well, on a bigger project, what I would normally do is we would go through each of the items that, each, Alpha, Bravo.
Approve them individually.
And approve them individually, right.
Yeah, I'm fine with the whole, everything together,
Okay.
absolutely.
There are a number of projects where we do that, only because there's usually some item that needs for some discussion.
Separate
Oh,
discussion, sure.
no.
Okay. Now,
Now,
did I cut you off?
No,
Okay.
we're good.
So now
All right.
it's fine.
Is there any other comments then on this one? Do you have any other questions for us for the project? Do you know where we're going? What do you need?
yeah, I think I'm fine. We're going to discuss preliminary and.
So do you want to make a motion for?
Yeah, so we'll make a motion
And we
for,
have- Sandy has the 5 points that we want to see
Yeah.
on the final document.
oh, okay,
Yeah,
perfect.
I kind of already have what I expected to say for your motion, so.
Okay,
Somebody move to grant preliminary approval subject to DEP approval, financial capacity, elevation 1 foot above wetlands, and Wayne's memo and the street light.
And written.
the written waiver,
For the road.
the waiver
standard.
request for the.
Yeah, waiver
4%.
request in writing.
All right, well, so would someone want to make the motion to what?
So I'd make a motion for preliminary approval based on the 5 items Sandy just listed.
Sounds good. Is there a second?
Second.
Any other discussion? Kevin, you okay?
I'm good.
All right, all those in favor?
Aye.
Is everybody? Okay, preliminary approval?
We got a 7-0. We haven't had a
7-0.
We haven't had a 7-0 for a while.
Right?
I
I
got
have just one question. So, would it be possible for us to come back in December, or is this something that
Yes.
you're thinking would need to go to January?
No, I have no objections. What, mile's got to be come back?
I was
Basically
thinking
just
March. I was thinking March.
March, yeah.
24?
Just keep on going. Yeah,
Just to give us some time to read it.
yeah, to
through and
really
stuff.
digest that. Yeah.
The big thing is,
Yeah.
Dustin, get me that. preliminary.
Yep. Yeah. So I can packet all this stuff up and get
No
it to Sandy
problem.
tomorrow.
Yeah.
I just want to make sure today was a deadline, and I want to make sure we're okay.
Yeah.
Yeah, I think the biggest thing is just make sure she has time to get the notice out for the next,
Yep.
Which, yeah.
Yeah, you'll have everything tomorrow,
Well,
except for the DEP.
except for the DEP permit, but the rest.
Yeah.
Yeah, so.
so why don't we get the notice out? And Dustin, I think you don't have to have it tomorrow. I think, within a
Yep.
week or so, I think it's fine.
Yep.
It's not gonna, there's not a lot that we really have to digest from it at all. So, having a little bit of delay in there is, it's not a problem for me. Does the board have any problems with it?
No.
As
Yeah,
long as
so
you
we
get it
know,
before the packets go out.
yeah, a week, 10 days, no problem.
Exactly, I like to send one packet.
Right.
Yep. All right, very good. Thank you.
And do you expect to come back next meeting for the sketch plan review?
That will be in January for
In January,
Raymond Hills, yeah. And it'll be, I think the board will still review it as a sketch plan, but it'll have much more substantive information. It'll be more like a preliminary plan, amount of information, but we'll review it as a renewal.
As a sketch plan.
Yep.
Okay. All right, any other board's business?
We do have findings of fact for you to sign this evening.
Okay.
And the folks from Raymond Solar here to have their site plan signed.
Which
Oh,
goes with the
I
finding
forgot
of
about, I
facts.
was wondering what you guys did. We could have done that earlier. I'm sorry.
So we can take care of that after closure of meetings. We can have all that reviewed and signed.
Yeah,
You do have to vote on the findings of fact though.
for,
Raymond Solar and.
Oh, yeah, we
It's
can do
Raymond
that.
Solar, right?
Yeah, Peter, yeah,
Raymond
Peter was
Solar.
saying.
Which
Okay.
you should have a packet with front
Yep.
this evening.
yep. Yeah, the finding of facts is there. It's here
The
somewhere.
original for you all to sign.
You just need one copy signed.
Right, that's why I've got the original.
Ah,
Yeah.
okay.
What would it be?
I thought I had it. No, Jim, we don't have it.
I think it was in your deliverables tonight. Can you give it to me?
I got so much stuff there tonight, I don't even remember.
It was not in what you sent today.
Oh, I thought,
Yeah, I thought I sent this down. Maybe fixed it.
So while we're hunting, how are we doing on our ordinance work?
yeah, Alex, how we doing?
We're gonna get time crunched here fairly soon.
Yeah, so I think we'll be looking to December.
Yeah, it'll be an agenda item in December. for
It'll
sure.
be a workshop in December where we'll start. I think part of that workshop was Alex and I will put
This is the
together,
original one.
Thanks.
we'll put together some ordinance pieces for you and we can start the process. It's a workshop, I think, in December.
Yeah.
Okay, December, February.
Most of it's going to be pretty easy, I think, this year, with the exception of marijuana. I think that'll be the big one. So I would expect that that'll probably be the one that we will need to spend the most time on next month, because that's going to be the big one.
We have examples from other
Yeah, and
municipalities, state.
we have a draft, not that these guys want to hear it, but we also have a draft of a solar ordinance that we can go over
Yeah,
as well.
and that one's a little bit more straightforward,
Yeah.
but the marijuana stuff, and the reason why I say it's going to be a little bit more complicated is you guys will have a lot more decisions to make than normal. Where, what, and how. It's kind of some bigger decisions to make. We'll definitely want to dig into that at the next meeting.
Will
Okay.
we need to have, has this been vetted out with legal? I know, because it has some implications as far as retail versus.
Well, that's kind of all open to interpretation. The select board didn't, they didn't really say they were against or for anything. They really just essentially tasked you guys with doing that work for them and coming up with what you guys feel is the best option for the town. I believe we may have left it off at you guys will kind of put something together and we'll probably get their input before it goes to a public hearing. So the select board can have some, comment on it if they'd like, since it goes to them eventually anyways.
Is there a state statute or guideline on that?
For an actual ordinance?
Yes.
Yes. Well, sort of.
So we need to have a public hearing in March, right?
Yes.
So that gives us, February,
Yeah, really, yeah.
right? To actually finish the work in February if we're going to have it in March.
The good thing is, I said you guys have a lot of decisions to make. The actual laws are pretty specific, so there's really only so many options. It's really just going to be what do you guys think? Where do you want to allow it? What do you want to allow? And then from there, it's kind of all plug and play.
Okay.
The standard.
And what about the other ordinance work we're doing? Is that?
That's all clean up most of it.
And most of
all
it's clean up.
Okay.
Yeah.
Yes, so we have a.
Do we
kind of
wanna
a
look at
base
shoreline
solar
zoning
ordinance
again?
that we'll be looking at.
What's that?
We have a draft.
No.
You want to get rid of shoreline zoning? Is that what
I'd like
you're-
to,
No, don't talk
The
to me.
tree stuff, yeah?
yes.
Yep, I'm sure you.
Well, all the
may
Cape
wanna
is
add some
shoreline
things to it
zone.
Based on what I saw in
Yeah.
the last one, but we just.
And getting the tree cutting permit must be an issue. I think it is.
Same with the marijuana.
Yeah, it's
Marijuana, I know the thing with that is.
a big part of what we do, tree permits.
Yeah.
So yeah, we'll have
I'd
that
like
for
to
next,
explore that, but
Based on the ordinance.
we'll have
I
that
don't
for
want
next
to overburden
month.
us either.
Yeah, and Alex, don't forget too that there were those couple things that the appeals board wanted
Yep.
looked at.
Yeah, most of that's all
Yeah,
clerical
yeah,
stuff.
it's kind of
We'll be able to
just
kind of
housekeeping, but.
clean that up.
Okay, all right, I'm changing subjects. We need to vote for the finding of facts. None of us had gotten the finding of facts. I'm holding the one copy of finding of facts.
I didn't see that.
So,
We can do one of two things. You can,
I'm not reading any
you can either
pages.
commit, I mean, what we could do is, we can get it to you when you come into town, possibly a sign at the town hall, because we just do want to get these guys kind of free to do their next steps.
I would agree that, but I don't want to ask people to vote on something that they haven't read.
Nope. I think by signing it, you basically are acknowledging that you
Yeah.
accept it, so, I think you can come into town hall and sign it.
We've done that with others.
Yeah, we've done that with others, I know we have.
Mm-hmm.
So, we can get it to you electronically, and then you can review it, and, if you're satisfied, then you can sit down and sign it.
All right, so I'll ask the board here. Do you want me just to, do you want to vote on just the conclusions to the finding of facts? Or do you want to have an opportunity to come in individually and read the whole packet? What would you guys prefer to do?
I'm
Could you
okay
just
with
read the
conclusion.
conclusion
Yeah, I'm
for
okay
us?
with the
Would the
conclusion.
conclusion be okay with,
It probably would be.
Doesn't that say that we did?
we've already approved the project.
Rude part,
Yeah.
but this is just a matter of the findings, just
Yeah.
making sure we're accurate with everything.
All right, so
Is that,
fine with me.
And I think the conditions are probably the biggest thing that you guys
Yeah.
want to make sure that we've got accurate.
and I'll read that too. All right, so the conclusion, after the Town of Raymond, the Planning Board approved by 6-0 vote held on October 13th, 2021, with the granted waiver and the conditions, the application for the Raymond Blue Wave Solar Farm Project. Jeez, my glasses. I'm going to skip the other part. The board approved a waiver by a vote to 6-0 for the requirement under Article 10, Section E, Criteria F, utilities for the other utility lines shall be installed underground. We allowed some overground utilities. We approved it with 4 conditions of approval. The applicant will need to include a note to the private street plan to be recorded. The applicant shall execute and provide proof that a road association maintenance agreement has been established. The applicant shall follow all the requirements set forth by the Town of Raymond Fire Department and the Planning Board based on information submitted by the applicant indicating the Maine State Legislative Amendment, the State of Maine Net Energy Billing Program in July, did I get that right? In July of LD 936. Okay, so anybody follow that. Did you guys get the road association done yet?
No, I'd assumed that that was just an order of condition and that.
She doesn't have voting.
Oh, sorry.
We were gonna do the road association and recording of all that later, just because that appeared as a condition, so I wanted to make sure we had the site plan good to go, and then we would work through those conditions prior to, I mean, we're filing our DEP permit, Friday, so that's gonna take 6 months. So we're not, we wanted to make sure this step was good to go first.
That's fine with us.
Yeah, I was, and we're doing yeah, I remember all this, okay.
So they have 2 documents.
Yep.
Tonight you're just signing the site plan. They will need to come back for the right-of-way plan.
Yeah.
That needs to be signed and recorded, but tonight they just want the site plan, because that gives them to move ahead.
Yeah, and the DEP thing is because we were in that circular logic. Okay. All right, is there a motion to approve finding of facts, the solar project?
So
With the
moved.
conditions, moved, second. Mike,
Okay,
good, all those in favor?
aye.
Done.
So the only one that they have to come in, maybe Kevin.
No, Kevin's already signed it.
Oh, Kevin's already signed it.
He wastes no time.
All right, Kevin. Rock and roll. How'd you do that, Kevin?
Technology,
There's also need to sign these.
Yeah, you better, man. Come on, I want you signing on my line.
Jim, I got 2 types here. I've got one that's embraced.
Yeah, have to have Mary come back
You
and
should be a doctor with us. Something like that.
My daughter is
filming.
filming,
You
so-
don't have to be.
We'll have to record it.
Oh, you have to record it.
She's getting cold.
You want the black one back, is that what you're saying?
Even though she had,
I just want to leave. I'll leave the black one.
Okay. Well, we'll sign both of them for you.
my daughter wanted to
Take
get
one.
both of
You're
them
gonna sign them
shots.
now?
Yeah. Really?
Okay, before we get too sidetracked, is there any other business you guys have?
Next month, we have,
Oh, is she okay now?
Oh, hang on.
just Dustin, right?
I think so, yeah.
I think the only thing you have to
You've got a new major subdivision pre-application. You should know that. It was out of your office.
Oh, yeah. So there you go.
13 lots.
So I understand.
Apparently.
Well, we have a,
Other than that,
we do have a subdivision coming in on Raymond Cape.
Work today.
Pre-application.
Okay.
That's why I asked Mary that
Hey guys,
question.
please.
We have a pre-application for that coming in. Sebago Technics is doing that, so I'll be stepping down. Will Haskell will be taking my role.
Okay.
And then we'll have Dustin coming back for final on, for Boulder Bend.
How big is the Cape?
I think that's a
13
major, I
lots.
think it's 14 lots.
Oh, okay.
13.
13?
Mhm.
13 in an open space, so,
Cluster, right?
yep.
Yep. Being constructed in a parking lot area?
No. Well, that's not even funny.
Right?
That's pushing it. Other than that, I think the only question would be is with the workshop, do we want to do the workshop early or do we want to do it after everything else? Because you have a sketch plan that's probably going to go relatively quick and then the final will go relatively quick, but do you want to do the workshop earlier?
What do you guys want to do? You want to work a little later or you want to start a little earlier?
I prefer earlier, but
Yeah, really.
I'm flexible.
Earlier? Earlier?
Earlier is fine.
Earlier is fine? Okay, so earlier is good.
6 o'clock.
6 o'clock?
Yeah, it gives us an hour to kind of work through the workshop. It's more of an introduction as to what you'll see.
Okay.
And then we can have a Q&A session basically and give us direction as to what you want us to do going forward. Obviously, we'll have to prepare them for final, but then you can give us any feedback if you want any more information or if you want any additions or subtractions or whatever. That way we can be really ramped up for January to have the next document for you so that we can schedule for a public hearing in February.
Yeah.
Great.
Perfect.
All right.
Adjourn.
Second? All in favor? We're done. Thanks, guys.
You got the document over here to sign this evening before